When it comes to intellectual property disputes, and by the way, intellectual property is referred to as IP for short, there are several things that you can do to protect yourself. Most notably, you should make sure that any of your intellectual property rights or registrations are collected and available to you. The other thing that you need to make sure that you have is all of the potential evidence that might be important if and when you are going to pursue your rights in a court of law. On the flip side, if you are unfortunately being sued for an intellectual property dispute, there are also certain obligations that you have. Again, you need to make sure that all the evidence that might be relevant in a court is retained. If you don't retain it, you'll have what's called a spoliation claim. And spoliation claims are quite bad for defendants in cases because the court will assume that any information that's not available to them would have been negative for you. So largely when it comes to IP disputes, you want to have the information that's going to be necessary to pursue your claim and the information that'll be necessary in an evidentiary context. And making sure that you have that information and retain it is probably the most important thing you can do in litigation.